approval of the agenda. Um, We'll pledge allegiance. We'll approve the agenda for last month. We'll have old business. We'll have new business. And under new business, we've got a quasi-judicial public hearing, application CPA 18-03, which is an application by the City of Newberry for small-scale plan amendments to the future land use plan map of the City of Newberry Comprehensive Plan. It's to change the land use category from Alachua County Agriculture to City of Newberry Agriculture on properties previously voluntarily annexed into the city, identified as Alachua County parcel numbers 02667-005-000 and 02667-002-000. We'll announce a date. The application will first be heard by the City Commission. B, quasi-judicial public hearing, application LDR 18-06, which is an application by the City of Newberry to amend the official zoning atlas of the City of Newberry by changing the zoning from Alachua County Agriculture A to City of Newberry Agriculture A on properties recently annexed into the city, identified again as Alachua County parcel numbers 02667-005-000 and 02667-002-000. This application is contingent upon approval of application CPA 18-03. And again, we'll announce the date the application will first be heard by the City Commission. C is another quasi-judicial public hearing, application SE 18-01. It's an application by Walker Lee, agent for David Budd Leisure, I guess I said that right, for an amendment to an existing special exception to allow retail sale of liquid propane gas and saltwater shrimp and fish in the commercial central business zoning district on approximately half acre in conformance with sections 4.13.5 and 4.2.35.3 of the Land Development Regulations. The property, identified as Alachua County parcel number 02191-000-000, is located at 25110 West Newberry Road, Newberry, Florida. At that time, we'll also announce the date the application will be first heard by the Board of Adjustment. Number 7 is topics from members for discussion, under which we have election of officers, and 8 would be adjournment. At this time, I'd like to see if make a motion, or if anybody wants to make a motion. Do we want to move 7 to 6A while we're waiting for our legal counsel?
Motion? Oh yeah, I'm not on two. I move that we move the election of officers to actually old business since it was new business last time. That would be appropriate. That would make it under 5, would be 5A.
I have a motion. We have a second.
Second.
All in favor?
Aye.
Aye. All right. Carries unanimous. All right. All those in approval of the agenda with the moving of 7 to 5 for old business. All those in favor? Or do we have a motion to
I move to approve the agenda as amended.
I second.
All those in favor?
Aye.
Aye. All right. Motion is unanimous. If we can, stand for a Pledge of Allegiance. Jessica?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right.
Mr. Chair,
Yes, sir.
I just want to let the board know we've had these new microphones now for 3 or 4 weeks, and we've got a lot of great reports from people watching at home and on YouTube, as long as you actually kind of move up and speak into it. If you're back here, not so much. So they're really good microphones. Everybody can hear at home, but you do have to remember first to turn it on and then to get kind of close to it.
Thanks so much.
All right. Everybody got that. All right, everybody have an opportunity to read last month's minutes?
Make a motion, we approve them.
Second?
Got a motion and a second. All in favor?
Aye.
Aye. Unanimous. All right. Bring us to old business, which was now our election of officers. First thing I want to do is take this minute to welcome our new member, Naeem. You want to give us an idea of why you wanted to be on the board? Or you want to say anything? Or
Well, thank you very much for having me. I thank the commission for voting me in. Very grateful for the opportunity. And I'm just here to serve our community in the best way and honest way we can. And like I said before, I just look for all the facts and everything, kind of like Judge Friezo, and just show me the numbers, and I go off of that. So, and I hope that we can help City of Newberry continue its growth path and properly maintain it.
well, welcome aboard. All right. Well, this evening we're going to be nominating a chair and vice chair. We lost our chair. He was taken away from us by being elected to the City of Newberry Commission. Does anybody want to throw something out there for chair?
Do you make a motion for that? I make a motion to have Walt Boyer be the chair and Bill Conrad be the vice chair.
We got a motion on the floor. Is there
I'll second that motion if that's a motion on the floor.
any discussion? There being no discussion, any discussion from the audience, the public? All right, there being none, we have a motion and a second. All in favor?
Aye.
Aye. All right, motion carries unanimous. Well, thank you.
Congratulations.
All right, well, that didn't take as long as I was hoping.
Mr. Chair, I would pose that you could probably work through the swearing in. Our planning can swear people in, and you can go ahead and let staff do their.
Let staff-
Well, let's go ahead and read through the quasi-judicial procedure. I'm sure that by the time we take care of some of those housekeeping things, Scott will be here.
All right, then why don't we go ahead and do that? All right, so new business. A, quasi-judicial public hearing, application CPA 18-03. And there he is. It's an application by the City of Newberry for small-scale plan amendments to the future land use plan map of the City of Newberry Comprehensive Plan. It's to change the land use category from Alachua County Agriculture to City of Newberry Agriculture on properties previously voluntarily annexed into the city, identified as Alachua County parcels number 02667-005-000 and 02667-002-000. And upon completion, we'll announce the date the application will first be heard by the City Commission. All right, since this is a quasi-judicial meeting, I'll read you the procedures that we're going to use this evening. The procedure is to ensure that the applicant provides a complete presentation of their request prior to any testimony being provided by the staff. All public testimony will be taken under oath. Everyone testifying will be subject to cross-examination. All documents and exhibits shall be entered into evidence. The giving of opinion testimony is limited to experts, and closing arguments will be limited to the evidence of record. The procedure we will follow this evening is that we will, number one, first hear from the applicant, and the applicant's presentation has no time limit. Number two, the applicant will then be subject to cross-examination. Number three, the staff will then enter the staff report into the record and answer questions. Number four, the applicant will have the opportunity for rebuttal of any testimony against the application. Number five, the floor will be open for public comment. Each presentation will be limited to 5 minutes. Members of the public will have an opportunity to question the applicant or staff. Number six, The applicant will have opportunity for closing arguments. And number 7, the public hearing will be closed and the commission will enter into deliberations. At this time, on this issue, I'd like to ask any of the board members or staff if there's any ex parte communications?
No.
No.
None?
Mr. Chair, I've had many conversations with the applicant on this topic, probably going back over the course of years. I don't believe any of those conversations, I'm not a voting member anyway, but I don't believe any of those conversations would hinder me in any way from offering advice to either the board or the applicant.
Okay,
But
thank
I've
you.
had lots of
Remind you, Mr. Mayor,
conversations.
that the applicant is the city of Newberry, not the landowner. We're just doing an administrative change.
Thank you, yes.
From county.
I'm
ag to
sorry, I'm
city.
sorry,
Yeah.
I'm jumping ahead anyway.
Yeah, what kind of influence do you have over the city?
I'm all into disclosing ex parte. I have not had any ex parte on this applicant.
All right. All right, all those here to speak on behalf of this first issue, we need to administer an oath. So if you're here to speak on the first issue, please raise your right hand, or stand up and raise your right hand. That's it? Okay. Do you hereby swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? All right. You are on.
Okay.
State your name for the record, please.
Mr. Chair, my name is Wendy Kinzer. I'm the principal planner for the city of Newberry, and I'm presenting your staff report, and a copy has been provided for the record. As you know, we had some annexations that were approved by the city commission back in May and in June, and they were each 5-acre parcels, voluntary annexations that were brought forward by applicants. And then once those properties are annexed, the typical procedure is to then bring those properties into compliance with the City of Newberry regulations. So the land development regulations include the future land use plan, the future land use map, the comprehensive plan, and the zoning atlas. So the first step then, in this case, you have 2 different parcels. Then, let's see if we can get this going here. And the first slide showing you the location of the 2 parcels. You've got, both of these are about 5.5 miles south of Newberry Road. And you see the one is just off of 93rd Avenue and the other off of Southwest 90th Avenue. So they're each 5 acres. They're now in the city. And the next steps we have is, for the future land use map, we changed that. And this is a small scale amendment. So this goes through a process where the city commission, after you make your recommendation, will hear this as well. And then they can make a decision to approve the future land use. And then once you get the future land use adopted, then you have rezoning. So you're able to hear both of those concurrently. And so that's why both applications are before you now. And this is a case where we're changing it from county agriculture, rural agriculture, which is their future land use, and their zoning is the county is agriculture. And then we're just changing it to the compatible district in the city's regulations, which is agriculture under the future land use and agriculture under zoning. So in this case, the small scale amendments, you have a handout that's attached to your packet that gives you some information about small scale plan amendments and how those differ. And in the sense of if they're under 10 acres, they can be processed just kind of like a zoning matter. And then we provide a copy of that ordinance to the state as a matter of courtesy. It's not something when we do the large-scale amendments and that has to go to the city commission, that has to go to the state, and then we wait like all the different agencies reviewing it. So this is not the case on this one. So in this case, then the next step after your future land use is adopted, then you have a rezoning that has to be adopted through ordinance. And because in this case we're having both of them go through at the same time, And you've got the two properties, they're both totaling 10 acres, so it's under your requirement for plan amendments, and it's considered small scale. And then you've got the next one is the rezoning, so that's going to come after this. But both applications, you have an ordinance for each one for the plan amendment, and in this case, you are just asked to consider whether you would approve the land use change on both of those properties to go from rural agriculture under the county designation to agriculture under the city designation. So you'll note that the rezoning that's going to be the next application that you hear, that's contingent upon the approval of the comprehensive plan amendment, because your zoning is what implements your comprehensive plan. So this first action that's requested of you tonight under the CPA, the comprehensive plan amendment, is to recommend approval to the city commission, the adoption of the ordinance for the plan amendment. Do you have any questions that I can try to answer for you?
Anybody have any questions for? No. No? All right. Are you speaking on behalf of staff as well?
I am staff, and we do have one applicant. Both. We have both. And I don't know if they would like to have a word. That would be. These are applications on behalf of the city of Newberry as a matter of just the way we bring it into conformance with the comprehensive
Correct.
plan, just administrative type of thing. But
Okay.
it's still affecting their property. So
Correct.
if they had anything
Well,
to say.
if you want to speak, I need to swear you in. Okay. I guess nobody's really got any questions. Okay. That takes care of a whole lot of these steps. Is there, anything else you would like to add to this before I turn it over to the board for deliberation?
Nope, that's it. So this is just a plan amendment where you'll take action, and then you'll take action, introduce the rezoning, and then you can take action on that one as well.
Okay.
For your public.
Is there anybody in the public that wants to speak to this? All right, there being no public comment, anybody on the board have anything to say? Is anybody want to offer a motion?
I'll make a motion we approve CPA 18-03.
Okay, there being a motion and a second, all in favor?
Aye.
Does the attorney have to read the title to the ordinance before we
Well,
approve?
yeah, he's distracted. Can the attorney go ahead and read the ordinance by title, please?
I'm not sure that I have it.
I can read it if you'd like, Scott.
If you like.
The
Mayor,
ordinance-
I'll still call you Mayor Conrad. That's right.
An ordinance of the City of Newberry amending ordinance 4-91, amended relating to an amendment to the future land use plan map of the City of Newberry Comprehensive Plan of 10 or less acres of land under the small-scale development amendment procedures established under the small-scale amendment provisions of Section 163.3187 Florida statutes as amended, providing for a change in land use classification from Alachua County rural agriculture, less than or equal to 1 dwelling unit per 5 acres, to City of Newberry agriculture, less than or equal to 1 dwelling unit per 5 acres, on certain lands within the corporate limits of the City of Newberry, Florida, providing severability, repealing all ordinances in conflict, and providing an effective date.
And Mr. Mayor, the appropriate motion is to recommend approval of ordinance number 2018-11 as read by title only for consideration by our city commission.
Was that your motion, Ms. Wanda?
Yes.
And was that your second, Ms. Jessica? Then we're all good to go.
All right. Now, all those in favor?
Aye.
Aye. Unanimous. Motion carries. The application will be heard by the City Commission on July 9th. All right, so that brings us to B, quasi-judicial public hearing, application LDR 18-06, an application by the City of Newberry to amend the official zoning atlas of the City of Newberry by changing the zoning from Alachua County Agriculture to City of Newberry Agriculture on properties recently annexed into the city, identified as Alachua County parcel numbers 02667-005-000 and 02667-002-000. This application is contingent upon approval of application CPA 18-03, and then we will announce the date the application will first be heard by the City Commission. Okay. Again, since this is a quasi-judicial meeting, I will again read the procedure. So the procedure is to ensure that the applicant provides a complete presentation of the request prior to any testimony being provided by the staff. All public testimony will be taken under oath. Everyone testifying will be subject to cross-examination. All documents and exhibits shall be entered into evidence. The giving of opinion testimony is limited to experts, and closing arguments will be limited to the evidence of record. The procedure we will follow this evening is that we will, number one, hear from the applicant, and the applicant presentation has no time limit. Number two, the applicant will then be subject to cross-examination. Number three, the staff will then enter the staff report into the record and answer questions. Number four, the applicant will have the opportunity for rebuttal of any testimony against the application. Number five, the floor will be open for public comment. Each presentation will be limited to 5 minutes, and members of the public will have an opportunity to question the applicant or staff. Number six, the applicant will have an opportunity for closing arguments. Number seven, the public hearing will be closed, and the commission will enter into deliberations. Once again, I'll ask if there's been any ex parte communications on this. No, on myself, my part. Wanda? No?
No.
All right, there being none. Anybody wishing to speak to this item, you'll need to be sworn in. So if you're going to speak on this, please raise your hand, or stand up and raise your hand. All right. Do you hereby swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? All right, thank you. You're on.
Mr. Chair, this is the rezoning that would implement the comprehensive plan amendment that you just heard. And in this case, your property is the same, or not your property, but the applicant's, the application, the property that's under review is the same property, and the request is to go to agriculture from the county agriculture designation to the city agriculture designation. And again, your recommendation is requested to go to the City Commission that they approve the ordinance that would adopt that change in zoning. And note that the effective date of the comprehensive plan amendment, when it is approved, if it is approved based on the City Commission's vote, then it's 31 days from the date of approval. So, and there are 2 public hearings that go before the City Commission for their review because you have an ordinance that you're adopting. So each item will be heard on July 9th, and if the Commission forwards that, it goes on July 23rd. And then from that time, if it were to be approved, the effective date of those ordinances would be August 23rd. So just as a matter of course, that's just through the statute and through our regulations. So.
Thank you. All right, any questions from the board? All right. Mr. Walker, would you like to read the title by ordinance, or the ordinance by
Mr.
title?
Chair, I'm happy to do that. This time I've got it in front of me, ready to go. Ordinance number 2018-12, an ordinance of the City of Newberry, Florida relating to the amendment of the official zoning atlas for the rezoning of less than 5% of the total land area of the city pursuant to an application by the City of Newberry, amending the official zoning atlas of the City of Newberry Land Development Regulations, providing for rezoning from Alachua County Agriculture A to the City of Newberry Agriculture A, on certain lands within the corporate limits of the city of Newberry, Florida, which have been annexed thereto, providing severability, repealing all ordinances in conflict, and providing an effective date. The appropriate motion is to recommend approval by our City Commission of Ordinance 2018-12 as read by title only.
So moved.
All right, all right, there being a motion and a second, do we have any comments from the public? All right, there being none, how do we have you want to vote yay or nay? I mean, give me votes, guys, come on.
Well, when you call for it.
All in favor?
Aye.
Aye. Ayes have it, it's unanimous. All right. Again, the date the application will first be heard by the City Commission will be on the 9th, July 9th. All right, so that brings us to our C. It's another quasi-judicial public hearing. Application SE 18-01. It's an application by Walker Lee, agent for David Budd Leisure, for an amendment to an existing special exception to allow retail sale of liquid propane gas and saltwater shrimp and fish in the commercial central business zoning district on approximately half acres in conformance with section 4.13.5 and 4.2.35.3 of the Land Development Regulations. The property, identified as Alachua County parcel number 02191-000-000, is located at 25110 West Newberry Road, Newberry, Florida. And again, at the end, we will announce the date it'll first be heard by the Board of Adjustments. All right, so again, this is a quasi-judicial procedure, so I'll have to read this again. This procedure is to ensure that the applicant provides a complete presentation of their request prior to any testimony being provided by the staff. All public testimony will be taken under oath. Everyone testifying will be subject to cross-examination. All documents and exhibits shall be entered into evidence. The giving of opinion testimony is limited to experts, and closing arguments will be limited to the evidence of record. The procedure we will follow this evening is that we will, 1, first hear from the applicant, and the applicant presentation has no time limit. 2, the applicant will then be subject to cross-examination. 3, the staff will then enter the staff report into the record and answer questions. 4, the applicant will have the opportunity for rebuttal of any testimony against the application. 5, the floor will be open for public comment. Each presentation will be limited to 5 minutes. Members of the public will have an opportunity to question the applicant or staff. 6, the applicant will have an opportunity for closing arguments. And 7, the public hearing will be closed and the commission will enter into deliberations. I'll ask at this time all those that are here to speak on behalf of SE 18-01. Please stand and raise your right hand. Do you hereby swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? All right, thank you. Oh, yeah. On this issue, I'll ask the board if there's any ex parte communications.
Yes.
Okay.
Friends with Mr. Lee and have had discussions with him
I'll
over the
have
years.
to speak up, Nick, because I can hear every third word. Please.
Say, I'm friends with Mr. Lee and have had discussions with him over the years. I just disclose that I don't think we have discussed this particular issue,
No, I don't think we discussed
but
this one.
I don't think that affects my judgment of this case.
Naeem?
No.
I shop there.
No ex parte communication.
I don't.
I'm friends with Mr. Lee as well. We've talked about this specific issue. I don't think it hinders my ability to advise on those conversations or answer any questions. Again, I'm a non-voting, so I would just be answering any questions that are directed at me anyway.
All right. All right.
Okay.
Mr. Lee, if you can, state your name for the record.
Walker L. Lee.
All right. And the floor is yours. The floor is yours.
The floor is mine. I am praying to the board to be able to sell propane at the stand. I'm also praying, since I didn't know I couldn't sell shrimp, to be able to be legal to sell shrimp and seafood. I've had my seafood license for ever, state license. I took I had Wilson's Gas contact the state. The state came out, looked at the property. We had a site plan drawn up, and the state approved the site plan without any problem. I think staff's got a little bit of problem about me being in competition with other people. I didn't know competition was a bad thing. I don't know if I'm not playing on the right playing field, but that's what I'm here for, to get approval from y'all so I can go in front of the city commission.
Now, are you looking for approval, or is this two separate approvals here for LP gas and for one for shrimp and fish? Because gas and seafood selling is two different things for me.
I've sold shrimp and fish forever. I did not know it was legal until our distinguished mayor told me it wasn't. And I'm here to get approval for it, yes.
And it's one issue, but there's two issues in it.
There's two separate issues, exactly.
Yeah, that's what I was trying to clarify. So it's not saying,
Yep.
you know,
No,
one
I'm not using-
encompasses everything. That
I'm
was my
not using the
clarification.
propane to cook shrimp.
So you can approve one, the propane, you can approve the shrimp and fish as one item. You can approve them both, or you can deny it all. Those are your real options that you have this evening. The last option would be to table it for a date certain in the future if you felt like you needed more information, but those are really your options that you have this evening.
Thank you.
Sure.
Okay, like I say, the state, we drew up a plan for where the product was going to be placed, the safety of it, the barrier of it, and everything. And the state has already approved the plan. Okay, I did not realize I would have to go through this part of this to get it approved. But since I'm under a special exception, I do have to come back and get it taken care of. And that's what I'm here for. So y'all to vote yea, nay. Let me take it to the city commission.
Mr. Chair,
Yes, sir.
just for the board's edification, when the produce stand moved from its old location next to Badcock's, I think Badcock's was still there,
Yeah, Badcock
to the
was.
new location, I'm not sure what he was operating under at that point in time, but we were trying to get him legal. But the special exception that we granted him was only to sell produce. So that's why the shrimp, other items got left out, because the special exception is pretty limiting. It says exactly what you can and you can't do. And it was, at the time, he was only a produce seller, and that was what we were focused on, was selling the
I
produce.
also had shrimp at the time.
So that's
I've
what,
had shrimp forever.
Yeah.
It was just left out of the first exception.
I don't have any memory of that. I know that we were doing the produce, and that's what we wrote it up as. So I think that's what we're here to try to correct on that front.
Exactly. We've grown from me and my wife to, I think there's, 6 employees now. I think the community is well accepts us. I don't think I have any problem. I don't see anybody here that's, going to talk against it that I know of. So I'm just asking for y'all to approve. Let me take it to city council and we'll see where it goes from there.
My question to you, Mr. Lee, is what exactly did the state approve you for? Did they just, the state, when you say the state approved you, what is it exactly?
The site plan.
So they didn't actually approve it to be done, they just approved the planning of the site, that's,
No, they approved that I could do it. The
Okay.
state did. They approved the plan where I can put it and everything, guidelines are there. But I have to go in front of y'all so you can say I can do it. Even though the state said I can, I'm still in the city limits of Newberry, so I have to live and do by your rules.
And right now, is that plan in compliance with other businesses that have the same selling of LP gas?
I have no idea.
Okay.
I have no idea. I know there's, you've got Ace Hardware that does canisters. You've got the Circle K or the Kangaroo, whatever it is, that does canisters. You've got Pickett's that does fills on the road, right beside the road. And you also have Florida Public outside of town that does propane, that does filling. So it's not that I'm not asking any different or anything than what they are, other than I don't have a brick and mortar building.
So my biggest concern, Mr. Walker Lee, so you can understand where I'm coming from, I studied this quite a bit when I got your paperwork. LP gas seems a little bit more serious than with all due respect, some produce and shrimp. With that being said, I see that our compliance or code enforcement has gone out to your property several times to see if you're up to date on multiple occasions for something so simple as yard signs.
Yeah, I took, there's been quite a few signs out there.
Okay,
I also put in, now you want to bring up all the spec stuff, we can go there. I also put in a drawing by one codes enforcer to have a sign approved. October was a year ago. Okay? All the political signs were up there also. Ted Yoho's sign's up there right now. So as soon as we get to one thing, I will put a sign up without any problem at all. And
So-
I told both codes enforcers this came. So now,
So it's beyond the signs. If we continue, it's also landscaping, planning. There's just several things on here that kind of concern me that if code enforcement's having an issue by getting this done on multiple occasions, my concern is LP gas is a little more serious than signs.
LP gas has to be state certified, trained to distribute. I can't just go out there and do it. I have got to be state trained, state qualified, and set a number to do it.
Mr. Chair,
So it does not have anything to
Yes,
do
sir.
with code enforcement.
just as, Mr. Walker, just as a point of order and to keep everything kind of civil, it's best, and it's actually in our rules, that the applicant will address all his questions and comments to the chair, and we try to limit direct back and forth. So let the board member ask his questions and make his statement, then give the applicant a chance to respond to that through the chair. That way everybody can get a chance to finish their thought before.
And I
Yeah, before you
apologize.
jump
Yeah.
on it.
No, and no offense, I'm just trying to find facts, yeah. Like I said in the beginning, I apologize ahead of time. I'm just trying to uncover all the facts and all the details here before, so we can make a correct choice. And that's where I'm at, is the seriousness. I understand that you have to get approval by the state to sell this. It's a little more serious than just selling produce. But like I said, my concern is something so simple as some yard signs, landscaping issues. If the compliance is not there and code enforcement's been asking multiple times to be compliant, my fear is if the state's coming down and asking you to be compliant. Now, the only reason I bring this is not just on the fact of the state shutting you down of something happening, but the effects and the impact it would have on our community, because now it's beyond our control because the state shut you down because you weren't compliant with the state, because you haven't been compliant with our code enforcement. That's my ultimate concern.
All right, so we'll, go ahead, Mr. Walker. You can finish your presentation, I'm sorry.
I see you got the officer back or something.
Go ahead, Mr. Walker.
What, I gotta answer something now?
No, just, I mean, if you want to add anything else to your presentation.
I don't see, you talk about license. I've got a commercial fishing, saltwater fish license, retail license. I've got a license for Department of Agriculture. I am licensed, I've got 5 different licenses that I carry. I'm insured. I got people that work for me, right? And as far as the sign doings, it has just been a little ifs, ands, and buts. So if they would approve a sign, I'd be more glad to put one up. I don't know how many times that you've got in your records that the codes enforcer's been out there to talk to me, but I don't think it's nearly as many as, so we're gonna let it go there.
All right, does that conclude your initial presentation?
That's fine.
All right. All right, at this time, we'll open cross-examination. Anybody want to ask Mr. Walker anything? Wanda?
No, at this time, I'd like to hear a staff report, and then maybe we can have more discussion.
Okay. All right, at this time, I'll call staff up, make their report.
Thank you, Mr. Chair. I'll give a little history on the purpose of a special exception. Basically, special exceptions are designed to allow for a use in a zoning district that isn't necessarily allowed by right, but certain conditions are imposed so that that special exception can be approved. The conditions established in a special exception are basically to ensure the safety and welfare of the community at large, and also the compatibility with the adjacent and surrounding areas, whether businesses or residences. The concept of granting a special exception is not to give one party some kind of a special privilege that's not shared by other businesses or persons of a similar category. But it is to, as it says, to make an exception to allow for a limited scope within the zoning district where it's located. And when the approval of a special exception is under consideration, the governing body does need to consider as many potential adverse impacts to the surrounding area, including, not just, but also including potential issues with surrounding businesses. Right now, the property in question is in what's identified as the Commercial Central Business District. In most of our commercial categories, sales, service, or storage of goods is prohibited except in completely enclosed buildings. It's a primary category in most communities. You don't see convenience stores per se, or hardware stores and those kind of things out in the open or under an open pavilion, other than maybe like a flea market type situation and situations like that. We do, however, have provision for special exception in the commercial business district zoning category for freestanding commercial pavilions, which is what Mr. Lee is currently operating under. And so that special exception to operate a commercial business under an open-sided pavilion comes with the limits that are outlined in the resolution that approved it.
Mr. Chair.
Yes, sir.
Could I just happened to remember, because I was the commissioner at the time who made the argument, the argument to allow the special exception at the time was that we did not have an open air market. And at that time, our ability for residents in that neighborhood to have a place to get fresh food was very limited. So it fit a specific need that we didn't necessarily have at the time. That was sort of the parameters upon which we made the decision to issue the special exception. So I think it was a couple slides before about what are you looking for in a special exception? It's got to fit a need that we don't offer. It has to have a reason to exist, and that was the argument that was made 5 years ago, 6 years ago, something like that. So that's an example of how we got to where we are now.
Okay, so the subject property in questions at the corner of 251st and Newberry Road. The special exception, which was approved by Resolution BA 12-3 in 2012, allowed Mr. Lee to construct a 1,200 square foot open-sided commercial pavilion to operate his produce stand in the Central Business District zoning district. It established conditions under which the produce stand was allowed to operate, and it's in your packet. You can see the copy of the approval, the resolution, and the specific list of criteria. Most of the elements of the conditions were met, with the exceptions of items 1D, 1E, and number 8, primarily doing with landscaping and signage. There was a requirement to turn in a landscaping plan as well as a signage plan with the site plan, which were not met. And then item 8 actually got very specific in terms of landscaping requirement for basically visual screening on 3 sides of the open-sided pavilion. Basically a top-board fence with vegetation that would grow up and create a hedge and act as a screen. Right now, there is no permanent signage. There's a number of rotating kind of yard signs and banners and things posted up on the fencing on the property. Mr. Lee's been contacted, as we mentioned, a few times by code enforcement, asked to not use all the yard signs, and to come back with a permanent sign design application for a permanent sign. He did bring in a drawing to the building department, but if I remember correctly, it was a while back, and because of the size or the height or an element of it needed to have a lot more specificity and some engineering on it before the building official could actually appraise it and review it as an actual plan. And that's kind of where it sat. It hasn't really gone anywhere from there. So, but Mr. Lee has been asked to stop putting out the yard signs, which our sign code doesn't allow. And there is a separation in terms of the use of yard signs, temporary yard signs for commercial purposes versus nonprofit or political non-commercial purposes. The commercial signage in the yard signs, especially when it comes to in the right-of-way, but even on private businesses, is prohibited in the code, whereas nonprofit and just in general non-commercial signage is allowed, so to speak. It's not expressly prohibited. And so we generally, in political season, we will pick them up if they're in the right-of-way, but if they're on private property, we don't pick up political signs, and we don't pick up commercial signs off private property as well. Then it becomes a code enforcement issue. But if it's in the right-of-way, then either code enforcement officer or one of the building officials inspectors will pick them up. Also, to date, the top-board fence has not been constructed, and there aren't any plantings put in for screening that were required under the original BA 12-03. And so Mr. Lee is currently in violation of a couple of the provisions that he was originally operating under in terms of landscaping and signage. And so he's requesting to expand products allowable for sale at the produce stand to include liquid propane gas as well as shrimp and seafood. As was mentioned, the current special exception only allows for the sale of produce. It was a limiting factor based on the fact that it was being granted a special exception to operate in an open-sided pavilion. And basically, the sale of other products outside of the scope of his original special exception would need an amendment to the existing special exception, which is the crux of the application before you. As far as staff recommendations, we do recommend denial of the request to sell LP gas at the produce stand. Staff feels that the LP gas is a more intensive type of product. It's not really it's not necessarily incompatible with produce, but it's not complementary type of product to produce. And whether it was LP gas or tobacco products or any number of other types of non-produce products, the recommendation would essentially be the same, for the very reason that expanding the allowable range of products for sale in an open-sided pavilion does represent, as Mr. Lee referred to, competition with other brick-and-mortar businesses, which are required to meet the code in terms of having an enclosed storefront or business to offer their goods for sale, and so that it represents a significant capital investment not made by operation of an open-sided commercial pavilion. And then, so for that reason, staff thinks expansion of the products, regardless of whether it's LP gas or anything else, would be providing an unfair advantage to Mr. Lee in terms of being granted the special exception that other businesses were not granted. The second recommendation would be to actually allow for the shrimp and seafood sales at the produce stand. That's a much more compatible type of product, we think. Mr. Lee has adequate refrigeration on site to handle that. As he mentioned, he's had his state license for a number of years to sell it. It's not uncommon to see a roadside shrimp or seafood truck or tent or something that, so it's a more commonly acceptable type of product on a roadside type venue. And for that reason, we don't feel it's that much of a divergence from what he's currently allowed to sell. And then finally, staff would recommend that regardless whether you approve one or both or none, any approval would be contingent upon demonstrated compliance with the existing conditions of the special exception in terms of the landscaping and the signage requirement. That concludes the staff presentation.
Questions for staff? We have questions for staff.
Well, yes, you can.
Brian,
The applicant first has the chance to rebut, is that right? Or do we have a chance for to cross-examine staff?
Well, it says the staff will
And
then
answer questions, so you can
enter
answer.
staff report and record and answer questions. So right now, we can ask staff questions.
Brian, was the application for a sign, was that given back to Mr. Lee and told him what was wrong with it?
Mr. Chair, when I spoke with the building official about that, he did state that he had spoken with Mr. Lee a year or more ago about that, and that told him that he would need to have some kind of engineering produced for the sign to assure that it was a safely constructed type of sign. It's again, I don't know what the dimensions were, but if you go over 6 feet tall, you have to have wind load engineering calculations done and those kind of things.
Can everybody speak up a little bit into the microphone, please? Thank you.
And so in terms of where that was left,
What happened with the sign we had before?
not a, basically, as I understand it, there was a conversation, and Mr. Lee was going to try to go back and get some kind of engineering or more substantial drawings for the sign to accompany the application.
So it'd have to be something like the one next door that just was approved, the sign that was next door at urgent care that was just approved, something similar to that.
Mr. Chair, there's pretty wide variability in the type of signs that could be constructed there. It could be a single board sign with exterior lighting. It could be a backlit sign. It's the property's not in the historic district, and so it wouldn't have to comply with the stricter set of regulations in the historic district. So it could be a sign like the Med Center sign that just went up. It could be designed such that you could display multiple product lines. Different types of boards could be hung up there to show different things that are in stock at the time. And there's plenty of room for creativity or variability. It just has to be shown that it's a safely constructed sign and meets the overall dimension requirements for the city, or limitations for the city, which is either you could have one big sign at 100 square feet, or you can have a two-sided sign, which is half. So you have 50 and 50 on each side.
question for staff. I'm all for businesses excelling in Newberry. How does one become compliant to sell LP gas like other brick and mortars in the area? I understand competition and whatnot and fairness, but is there, has Mr. Walker received exactly what he needs to be compliant with the city to sell LP gas?
Mr. Chair, that's basically the crux of this discussion here. Under the special exception, without amendment to it, there is no way for Mr. Lee to sell LP gas legally. It would require the expansion of what he's allowed to sell under the special exception. If he had a regular enclosed business storefront in the Central Business District on that site, he wouldn't need to come before the commission or the board and then the commission at all. It would be he'd be able to do that by right.
Mr. Chair.
Yes, ma'am.
So I have a question for staff. The original ordinance that the special exception was granted under says that any deviation shall be deemed a violation of the land development regulations. We've noted several places where they're in violation. What is the penalty for a violation of a land development regulation besides a code enforcement?
Mr. Chair, the penalty is basically through code enforcement. The initial step would be formal notification and a time period given an adequate time period given to come into compliance. At the end of that time period, if compliance was not met, then another notification that the violation would be brought before the special magistrate at some time scheduled forward. And then it would typically be up to the special magistrate to determine the penalty. But I believe ultimately the penalty and through code enforcement is as much as $500 a day if the magistrate went that far. But that's generally the penalty is if the violator will not come into compliance, then the special magistrate ultimately will issue some sort of a fine or period, generally grant them another period for compliance, and beyond which they would start basically accruing fines.
But the penalties all include fines and not for instance, you couldn't revoke the special exception.
Mr. Chair, actually, I believe Ms. Baker brings up a very good point that because it's operating under special exception, and as she pointed out, it would be deemed a violation of the land development regulations. It could be pursued as in that respect, and the special exception could be revoked.
Mr. Chair, would the special magistrate be responsible for that through a series of code enforcement non-compliance, or would that be something that the city would bring or the commission would bring?
It'd have to go through the same processes of granting of the permit, so it'd come back before you all. As far as the revocation, the code enforcement magistrate would not have that ability. He can only levy fines.
Would he initiate that though after? No.
It's got to be, he has no power to initiate anything. So
Okay.
his only authority and duty is to look at a complaint that's before him from the code enforcement officer, and then once that happens, then he could issue a fine up to, I think it's $200 a day. And each and every day that goes by is a separate fine under that scenario. But that's really his sole authority.
So, Mr. Chair, I have one further question. Since it appears that some of these, under the ordinance, the ordinance was passed as with these provisions, and some of these provisions were never complied with. What is the city's liability in allowing the non-compliance for 6 years of the special exception?
There's no city liability for that. It's a function of, we have code enforcement and they're pursuing it more vigorously or not, and that's changed as we've had city managers. I'll go back with Mr. Ashby's regimen when he was here. I think his idea was to try to get as much compliance between both residents and business owners, and to try to approach it in a manner that would bring about voluntary compliance as much as possible. And so I think that was really a lot of the approach that was taken then. I think Manager New has also followed suit with that same philosophy as far as his approach to it. I think there's been a bit of a change. We used to have a code enforcement board. It's hard to get members to fill that board, so we switched to either a dual way of doing it. One is code enforcement magistrate, second is the code enforcement board. We found it more successful to have an actual code enforcement magistrate recently, and so that's the process that we're using. We've hired somebody from Alachua County that is a very, very highly experienced code enforcement officer. My understanding from staff level is that we're gaining a lot more compliance because there's more consistency on our staff level now with code enforcement. So there's been a variety of things that have happened over at least the last 6 years, really 10 years, and it all points to different directions as to why things happen the way they have. But going back to your question, there's no responsibility or liability on the city's part for enforcement or non-enforcement of its regulations.
Mr. Chair, so I guess my question is, and I'm not trying to be like combative, but like in a situation where you have squatters' rights, if you don't check your property for a certain length of time and somebody's there, it becomes theirs. It can, if you go through the correct means. That if we have not followed up with the provisions of the special exception, have we lost some of those, the ability to enforce some aspects of that special exception?
It's a great legal question, I'll say that much, because in very many areas of the law, that's called latches, where the complacency occurs, and you just, by virtue of your complacency, then you lose certain legal rights, and that's the concept of latches. But we're considered the sovereign. You know, our laws come from England, so you can't adversely possess the king. You can't lose your rights because you're the king essentially. Even though we don't have monarchies in this country, our law comes from the monarchy in England, and so many of their rules emanate from there to over here politically, and it's very, very difficult to gain a latches concept against a municipality.
Okay.
So we still have the right to enforce, and for all the reasons that we were just talking about, because of staff funding, staff levels of ability to seek code enforcement, to process the code enforcement, all of those things are reasons why many times cities are left with an ability to move forward on certain areas. And if you look at our city now, I think you'll probably find a lot more compliance with code enforcement as we sit here today.
Can I ask a question to Brian?
Go ahead.
Brian, for Mr. Walker to be compliant with the special exception, he has to have a sign, and he has to put up a fence, and he has to do landscaping. Is that correct?
Mr. Chair,
To be compliant
that's the general
in the exception
missing
as
is.
is?
Yes, yes, ma'am.
Okay.
All right, Brian, what's the initial, when we grant a special exemption, what is the initial compliance period? What do we, hey, you got to have all of these, you have to have everything done by what, 12 months? What is the time frame we give a business owner when they seek a special exemption to comply?
Mr. Chair, that can actually vary from each special exception depending on the request for it, what it entails. Typically, the time limits are actually, the way they're written, are more in terms of we're granting you this special exception, here's your conditions, and if you haven't acted upon it within 6 months, 12 months, et cetera, then it reverts, but you lose the special exception approval. And so usually I haven't seen very many beyond 12 months. Off the top of my head, I think somewhere in the notes I saw on this one was 6 months originally, but I'd have to do further research to actually confirm that. But certainly 6 years is outside the timeline.
Okay.
As a follow-up to that, Mr. Chair, I think you have the ability to say, okay, if we're going to modify the special use permit or the special exception, you can say, okay, we want compliance with these items within a certain, in other words, you have jurisdiction over the matter now. It's modifying the existing special exception, and you can say, applicant, you are granted this benefit of a modification of the existing special exception, and we want compliance with these other items within 30 days, 60 days, 90 days, 6 months. But, you know, it's whatever you deem as reasonable. You can require the applicant to comply with the initial special exception and any other conditions that you think are reasonable as a result of this modification here this evening.
Okay, thank you.
I have a question, Mr. Chair. With a special exemption that happens here, if we go through with a special exemption to add more to this special exemption, with the free market the way it is, what would stop another flea market per se to start selling everything that Mr. Walker Lee's trying to sell, from the fish to the produce to the LP gas now? What would be put in place to stop just pop-up tents from going up every street corner or commercial plot per se to do this? Because at that point it's like a brick and mortar, the protection of brick and mortar have. It's kind of both ways. So I'm kind of trying to figure out what would stop others from just saying, well, he has a special exemption, now can I go get one?
Mr. Chair, basically someone else's ability to set up an open-sided commercial pavilion would be limited by their ability to obtain a special exception, and so they would have to go through the exact same process. They would petition the Planning and Zoning Board, and from the Planning and Zoning Board, you'd make your recommendation. The City Commission would then make the final determination on whether or not they would allow a special exception for another open-sided pavilion, and then what the conditions that commercial endeavor would be allowed to operate under.
So, so it would be fair to say that pretty much, if this special exemption is amended and granted per se, anybody can come up here and go ahead and petition and use Mr. Walker Lee's special exemption as a reason why they should be approved as well, and they most likely will get a approval.
Mr. Chair, my understanding with special exceptions is they're all, each and every one is considered a unique occurrence, and so the granting of one does not set a precedent. The city attorney would be better suited to address that.
You did a good job. And I agree with that because of the uniqueness. Each application, in other words, you have to look at that particular land, the surrounding landowners, which are unique to that particular instance, how big that property is, what is the ingress and egress, you know, what is the compatibility, and it all is very unique to that particular property in the granting of a special exception. And you could have a special exception application right next door to the existing special exception for Mr. Walker Lee and deny it because it's not compatible based upon that particular, so it's very unique. Each one's unique.
Thank you, Mr. Chair.
Mr. Chair, it's a question of staff, and I think this is probably for the attorney, but the root zoning of this parcel is Central Business District. So my question is, when he gets a special exception to have a produce stand there, does that completely trump the Central Business District zoning, or can he still do anything on that plot that is allowed in Central Business District, which I believe propane sales are, because his neighbors are doing the same thing. And you mentioned that the special exception allowed him to have an open-sided area. But propane sales are never inside brick and mortar. In my observation, they're always outside the brick and mortar. And you have to, you go out and get your tank filled, or you buy your tank. In the 3 cases we talked about in Newberry, tanks are always outside. And I think that's probably for fire safety reasons. So I don't see any problem with him having an outside propane sales. And just like at Pickett's, where you get your tank filled outside, then you go inside a gun store, which is completely different from propane sales, and make a payment. I don't see any difference between getting your propane tank outside of Walker Lee's and then going inside the produce stand and paying for it. So I don't really have a problem with that. And I think the question is, the sticky issue is compliance with the provisions of your previous special exception. And I think this is kind of being used as a lever to bring you into compliance. And Mr. Attorney, I'm kind of waiting for an answer from you on the central business thing. Is he okay to sell propane gas under Central Business District, or does the special exception take away all the things that are allowed to him under Special Business District?
Can I start? Mr. Chair, the special exception allows him to operate at all in the Central Business District. Without the special exception for an commercial open-sided pavilion, he would not be able to sell anything. And so the special exception grants him, while it grants him the ability to operate a commercial business, it limits what that commercial business is entitled to. There's a much broader range, of course, that could be of things that could be sold or done by right in the commercial Central Business District for a non-special exception situation. But by virtue of being allowed a special exception in any zoning district, it doesn't then automatically grant you the same rights to what other businesses would be allowed that were not operating under a special exception, but instead were operating by right.
Okay, so it has to come under the Central Business District, I mean, under the special exception.
Yes.
So I think where I differ from the staff recommendation is, I don't see it as that big of a departure from what other businesses are doing in that district, that I would recommend not allowing the propane sales. But I would recommend that he be in compliance with the previous thing. I went by there the other day and all the signs were gone. I think that put him back in compliance. I don't think your signage plan can be a blank sheet of paper that says, I don't intend to have any signs. And then, in that case, for a couple of days you were in compliance. Then the Yoho sign went up, but I don't know, maybe they put that up without you knowing it. But it did look like when all the signs were gone that he was back in compliance again. Now the 4-foot fence, not, but that might not be too hard to put up a 4-foot fence there, and then you'd be completely in compliance. So that's kind of where I stand on it. I know the propane is a departure from produce, but it's not a departure from what's going on in the Central Business District. So,
Do we have any more questions for staff?
Yeah, Mr. Chair, for staff on the propane issue, real quick, compliance purposes, like Mayor Conrad said before. Sorry, I still refer to you as Mayor Conrad. Mayor Conrad said it does make a lot of sense on the whole, if so-and-so is doing it, it's outside, it makes sense. However, my curiosity is the safety of the propane, Mr. Chair. Would there be orders to make sure that, safety mechanisms are put into place? I'm sure Pickett has several locks on their propane, as well as the Kangaroo's open 24 hours. But there's certain protection done to those propanes. Is there anything under the special exemption that would stop normal safety from the state procedure from a brick and mortar?
Doesn't that fall under the jurisdiction of state regulation?
State and the local as well. Mr. Chair, the staff has no concern or recommendation in terms of the applicant's ability to safely operate a LP gas filling station. That's not the crux of the issue to staff. The fire, if you were to approve it and the city commission were then to further approve the sale of LP gas at the location, the fire chief would come over and inspect it for compliance with the National Fire Safety Code as well as the state requirements, which was released at the site plan from the state. In the state terms has been complied with, and I think that's generally going to follow, of course, the National Fire Safety Code that the fire chief would come over and confirm. It basically, from staff's perspective, it boils down to how many different types, how far do you want to expand the list of products allowable for sale for an open-sided pavilion that was originally approved just for produce versus, businesses that he would then be competing with on a different product line that have made their substantial investments and are selling their things by right rather than by special exception. And that's the purview of the board and the commission.
Now, question. You mentioned LP refilling stations. We're talking about canister swap outs, aren't we?
No, we're not talking about.
Okay, you're actually talking about live filling
I'm talking about the same thing.
canisters themselves.
Same thing.
Okay, not like having Blue Rhino come in and
No,
swap out
no.
canisters. Okay.
State certified.
It'd be more akin to the facility at Pickett's, where they have the outside tank and the refilling station, where you can
Okay.
bring your own tank in and fill it up there.
Any more questions for staff?
Can I ask Mr. Walker something?
He's about to, I've got a, Mr. Walker, you got an opportunity to make any rebuttal against anything you've heard up here?
I know Mr. Cox.
Don't forget to speak into the mic there, Mr. Walker. There you
I
go.
know Mr. Thomas has not been here. He did not see the lot before I moved in with the house that was there, that was tore down. I spent over $1,500 just cleaning the lot up, just the lot. My property has never needed to be mowed. I mulch the parking lot at least once a year. My building, I've got $18,000 in. I've got $12,000 worth of coolers in it. I've got $3,000 worth of electricity in it. I've got a concrete slab for my coolers to be on. So I do have mortar. It is grandfathered in as a special exception, is how they worded it when it came into being. And if somebody wants to move in 2 blocks down from me, I would be fine if they wanted to sell produce. It's a free market. The sign, okay, I'll take a beating on the signs. Code enforcement for bushes, okay. But we all know how bad, everybody who was here, how bad that lot was. We also know I got a privacy fence put up. I am never dirty. There's never garbage left there. I think, if I'm not mistaken, I have got more, by far, landscaping than the new liquor store does, than the Kangaroo does, than the new Godfather Pizza does. So I'll do landscaping. But I've already got $3,000 invested in this little endeavor. So between the state, the tank, my mistake for ordering the tank, but I would really hope the board would recommend to put me on the same playing field. That's it.
All right, Ms. Wanda,
I
did you
wanted
want
to ask that Mr. Walker something,
Okay.
not him.
Okay, other one.
I just wanted to know if this was approved with the exception of, with a timeline that he had to come into compliance with would that be acceptable?
Yes, ma'am, that is your, within your discretion, so you can put a motion on the floor and say, okay, I want you to be in compliance with the original provisions of the special exception within so many days, within whatever your discretion is, and you have the right to do that. So, yes, ma'am.
Thank you.
All right, any other questions for Mr. Lee?
Mr. Chair, I'd just like to ask Walker, we've been scheduling stuff from today for the July 9th commission meeting. That probably doesn't give you a lot of time. If you're going to put up a 4-foot fence, how long would it take you to get in compliance, do you think, with it?
I put a fence up, barrier fence up, and I actually thought I was in compliance there. It's an open air market. People park on the street, they walk in. I don't want them walking out in the road, and I don't know why I should have to put a 4-foot fence up. Now,
You don't have
maybe
to put it up on that side.
that's, I'm afraid,
I think it says a 3-sided fence, and you leave the street on 251st Street without a fence, right?
okay, so I'm gonna put it along the back.
Oh, is that what we're asking him to do, Brian, is put a fence between his parking lot and the, I think we want the fence to be a barrier fence between his place and the neighbor, right?
Mr. Chair, the way it was written was there would be one behind. If you're facing the pavilion from 251st, there would be the 4-foot vegetative screening would be behind and on both sides.
Of
So
the
it would be
fence.
of the pavilion. So it would be screened. State Road 26. The view from State Road 26 would be screened, and the view from the parking lot would also be partially screened, and it'd be open to 251st. Is the way
Okay,
it was
there is
written.
a fence now behind my building, right, that runs in between me and Don Kelly, all the way down. There's a buffer fence between me and the electricity company, and another fence that runs down the other side of my property in the back where I have the barbecues and it's not a wood fence, but there is a fence.
Mr. Chair, as I've read it, and I've read through the notes from the original hearing back in 2012, the intent of what was specified, as I interpret it, is it was supposed to be more of a decorative nature. Otherwise, 4 foot tall, that way you can still see over it for security purposes, and also you can see some of the product inside and that kind of thing. But it was supposed to be more of a decorative design rather than a privacy fence type of a.
Yeah, it's kind of unusual wording, I thought, a 4-foot fence, and then you wanted
Like
pine trees on either side that would lean against the fence and make it look like a hedge.
I think it was vines, Mr. The vines that would grow up and encircle the fence.
Yes, sir.
Maybe Mayor Conrad can remember. I have no memory of discussing in public the fence.
I don't either, that's why I was
Yeah,
surprised
we may
whenever
have talked
I
about
saw
it, but
that.
6 years ago, I don't remember talking about the fence. I can tell you 100% that the existing facility now is much, much nicer than, I think it was a little white pop-up tent much safer. People had to kind of back up into the road to get out. So now it's much better. I would ask legal's advice on, because it seems like we have kind of a whole lot of issues. I think Mayor Conrad sort of alluded to it. We got the issue in front of you, which is just to let him expand the exception to LP and shrimp. That's really the only thing that's in front of you, and the staff is saying if you entertain that, they would like you to reiterate he's got to come up into compliance. If you want to argue with the notes that were written 6 years ago and change what compliance means, I would ask legal to give us a little bit of guidance, because that's uncharted territory for me. So I don't remember talking about the fence. If it's in the actual wording, you know, then we would have to address it. I just don't, it certainly didn't come up in my mind in the original conversation. We spent a whole lot more time talking about, would Hitchcock's be upset with us, or any other produce place be upset with us if we allowed it to happen? Because obviously those businesses have made significant upfront investments, and how much,
If I'm not mistaken, when we talked about it before, it was how are we going to handle it, like you said,
how are we gonna handle the traffic?
next time? How are we going
Right.
to handle it?
Yeah.
And
But hang on one second, Mr. Walker, before you, I want to get legal's opinion on this question, because it kind of sounds like there's some calling into question those, what the fence is and what compliance means, and I'm not sure we have the power to go back and override what the commission said, these are the things that you have to do to be compliant. So at this point, my gut feeling would be compliance means what's in that, whether we personally agree with it or not, compliance means what's in that right there. You could certainly, we recommend it come into compliance, and it would be noted in the minutes that we thought the fence was an unnecessary. Anytime you want to pipe up. I know you're doing some mad research over there on this question for me, but before we get down too many different rabbit holes here on this question, because we still really only have one issue before us that could be separated up into two.
Is there a slide that shows the property again, so we can see what we're talking about on the fence issue here?
And
I'm sorry, because I'm looking at it on a very small map, and I'm curious to see what we're talking about. So does the fence have to go on to Newberry Road here, the 4-foot fence?
No.
What's the story
Miss-
on the fence?
Mr. Chair, my interpretation of what I read in the reference to the fence was that it would be basically just around the perimeter of the pavilion itself, as a vegetative decorative screening mechanism, not the perimeter of the property.
Okay.
I didn't say my name earlier. It's Samantha Lee.
Mr. Chair, I think the question's been outlined appropriately. I think Mayor Marlowe has set forth what's before you. And I did speak with Brian. I think he concurs, and my assessment is that what you kind of have a second bite at the apple now. You have, and you're in somewhat of a better position to deal with what you're looking at conceptually, because it's no longer just conceptual at this point. So you have your original application and your original grant of the special exception. Now you have the applicant before you that's actually put the items that he said, the electrical, the pad, the coolers, and the structure is actually on the ground. So you're actually in a better position now to deal with the matter than you were back in 2012. And if you believe that those original conditions were appropriate, then as I stated earlier to Chairperson Lair, that you can set what those requirements are now. You can specify and delineate what you believe is the reasonable time. If you determine that you want to make the restrictions more stringent because of the new items that are being placed on this property, you can do that. If you want to relax the restrictions, if you want to change those restrictions, I think you actually have a second bite at the apple now to create buffers or do whatever you think is appropriate with regard to this property, because you have jurisdiction now to deal with this situation.
Okay, so if we like the aesthetic view of the produce stand from Newberry Road, we could recommend that there doesn't need to be a fence or a screening along the Newberry Road.
Whatever it
corridor.
is that you do, be very clear about what you're requiring now so that the applicant knows what his requirements are. Two things. One is to be very clear about the restrictions and conditions that you're placing on the special exception now. Number two, the second component is you have to set the time frame and say, okay, this is when we expect these things to be completed. And if not, we have a very much different code enforcement situation now that it will be dealt with if these conditions are not set forth. The other thing that you have the ability to do is say, okay, we want you to bring back a more delineated site plan at your next meeting, whatever you want to do. These are the things that you have available to you at this stage.
Okay, thank you.
Sure.
Mr. Chairman?
Yes, sir.
Since we're amending the special exception, I think we could make part of our amendment to change the wording of this paragraph 8, because I don't like this. I think construct a 4-foot board fence around 2 sides is 3 sides. I don't see where we can put, I think we can only construct around 2 sides, because the other 2 sides he's open, one's his parking lot and one's he's open to 26. I think that should have been said 2 sides. And then this was done by your predecessor, Brian, and it slipped by both Jordan and myself on the commission when we voted for it. But to add an opaque requirement, a quick-growing evergreen vine or plant type is to be planted every 2 feet along the outside fence and pruned so that the plant will use the fence for support and have the appearance of a hedge when fully grown. These plantings will be kept trimmed as a hedge 4 foot in height to allow for security and site requirements. To me, that's way too much. Where did we come up with that? Most of our buffering requirements say you must have a vegetative buffer 4 feet high or 5 feet high. I think we ought to take all that wording out of there and say, put a 4-foot fence across there. I mean, he could plant a bunch of kudzu in there and meet the requirement of this and have a really bad fence. So I'd like to take that out of it. You say you already have
There is a
4-foot.
There is a fence between me, my property, and all other properties besides the road. Again, I don't tell you what to put your flowers in your yard.
Right. And I don't, it shouldn't say 3 sides. I don't see a 3rd side you can fence.
Well, they wanted
Still
to
allow him
fence off
parking.
the Newberry
Mr.
Road
Chair.
side.
Just as you're still in quasi-judicial.
Correct.
So what I would recommend is asking him any direct questions you want to ask him about what he stated, so that you can open up for public comment, and then you can close the quasi-judicial, and you guys can enter into the exact kind of deliberations you're talking about.
Well, actually, my deliberation, we're still in the staff.
No, we are.
Okay,
rebuttal.
okay, that's right.
Just to kind of keep us on track with quasi-judicial. So if you got any more to grill Mr. Walker on, which looks like you.
Wait, okay.
Does anybody have anything
I
else?
do. Mr. Chair, have there ever, I know that part of the concern with the hedge many years ago from my recollection was light pollution. Have there been any complaints about how your pavilion is over the last 6 years?
Not in the last 4 years. Okay. And that goes back to a very definite difference in opinion with one other person. And I don't know whether you know who I'm talking about or not, but not since then. Nobody, ever. So,
Thank you, Mr. Chair.
All right, is there any other questions for the applicant? All right, at this time, we're going to open the floor for public comment. Each presentation will be limited to 5 minutes, and members of the public will have an opportunity to question the applicant or staff. Anybody out in the public? Okay. All right, we're going to close public comment.
Applicant has the opportunity to make a closing argument if he wants to.
That is the next step. At this point, the applicant will have an opportunity for closing arguments. Mr. Lee, do you want to offer anything as a closing? All right. All right, at this point, the public hearing will be closed, and the commission will enter into deliberations.
Mr. Chair, might I just offer, because it sounds like you guys have a lot of deliberations to make about how this is worded, but for the time's sake of the applicant, you might want to go ahead and figure out whether you're willing to approve both of the questions, or whether you're just willing to talk about the shrimp, or you're just willing to talk about the LP. And then, if you are willing to grant any of it, then you can get into all those other kinds of conversations. If you're not willing to grant those things, then I'm not sure that's worth anybody's time to go through all of the conversations about meeting the criteria and those kind of things. We could spend 30 minutes talking about how high the hedge should be, but if you guys aren't willing to grant the request, all that's kind of wasted time, in my humble opinion. So just as a,
Mr. Chair,
Is there a motion to,
motion.
what is your motion?
All right, so, go ahead. Oh, well, I wanted to ask a question
okay,
on
yeah,
the,
because
on
once
this
you
real
make the
quick.
motion, then we
Yeah.
might be locked in.
My whole question is this, as far as deliberation with the commission here, Mr. Chair, is I see where Bill Conrad's coming from. I think Mr. Walker Lee found a very good free market loophole, and I'm all for the free market as a pure libertarian. However, there are other buildings in compliance that have to go through rigorous stuff. So I'm willing to see if he gets into compliant with what's missing, bring us something to show in good favor for us to move forward with the other option. The shrimp and fish I'm 100% for. However, the LP gas I would want to hold until all other stuff comes into compliant, just to show that he will be in compliant going forward. Is that like just to entertain that thought?
What are your thoughts?
I'm good with what
I
Mr.
just
Eaker
want to
said.
be able to figure out where we're going to head from here. Wanda,
I'm
are you
okay
willing
with it.
to entertain one or both of the positions?
Yes.
Yes, I'm willing to entertain one or both.
Okay.
Okay.
Did you make that in the form of a motion?
I'll
You
go
did.
ahead and
You-
make
you
a form
just-
of a motion. I was
Okay,
just
okay.
asking
I'm just
how,
making sure.
how the thoughts on the board were.
Why don't we hold off on the motion until we discuss compliance, and then, so we don't have to amend the motion?
At least we know we are going to discuss it. Okay. Yes, sir.
Mr. Chair, I just wanted to offer clarification as well. One of the board members in the previous line of discussion mentioned the possibility that staff was looking to use this sort of as a leverage for compliance. And I just wanted to clarify that that's, in staff's opinion, that's not the issue. We're not trying to use this to gather compliance. However, if we're going to expand it, that would be the recommendation of staff, is to also require compliance. But as far as Mr. Lee mentioned something I wanted to address, which was he's asking to level the playing field. And I guess that's actually the rationale behind staff making the recommendation against the LP gas sales. The reason being, as an example, the brick and mortar businesses we've been talking about, if you look at the property appraiser, they're paying taxes on those brick and mortar facilities. The property that Mr. Lee is operating from, while he's made several expensive improvements, is still listed as vacant property. And is so, in terms of leveling the playing field, that's, to me, to staff, that's the crux of granting a special exception, is you're allowing the special exception to not play on a level playing field. And so that's why staff's hesitant to recommend expansion of what can be sold under that special exception for those very reasons, because you're already allowing the person who possesses a special exception not to be operating on that level playing field with the others in the area.
wasn't aware of that.
Mr. Chair, I have a question. Regarding that, even though it's then zoned the way it is, as vacant, does it pay a fire assessment fee?
Mr. Chair, to my knowledge, nothing that is listed as vacant is assessed a fire assessment fee, but I'd have to confirm that.
Is everybody kind of clear with that argument? Because that was the argument 6 years ago, and it's still the argument today. We can talk about hedges and fences and signs all we want, but the crux of the argument is from an economic development standpoint, trying to bring brick and mortar businesses in. What does it do to those brick and mortar businesses if I can operate and provide a lot of the same products in an open air market? So that was the question we argued 6 years ago. It's still the question in front of you today, is what does this do to the free market and competition, and you know, is the next person going to say, well, why would I ever build a brick and mortar business? I'll buy a carport, and I'll put a carport up, and I can sell whatever I want. Now, the answer to that is those people would have to come before you. They'd have to think about exactly what they want to sell. They'd have to come up with some renderings, figure out what it's going to look like, and they'd have to go through you. Then they'd have to go through the city commission. But if I'm willing to build a building and have that infrastructure, then I can do all of these things by right. A special exception is a favor. They're saying, look, we need a favor from you because, and last year, or 6 years ago, the favor was there is no fresh produce that a poor person without a car can get to, except for the produce stand. And that's why we need the produce stand. That's why we're asking for this favor. That argument wouldn't necessarily apply to LP because I've got pickets right there. I can walk to them if I need pickets. So the favor 6 years ago was fresh food is a necessity. It's a health need. The produce place sells it for cheaper than brick and mortar, and it's within walkable distance. So that's kind of the argument that staff is trying to lay out and say for economic long-term development plans, what types of things do we want to allow to happen under special exceptions, and what type of things are we going to say you have to make the upfront investment in order to happen. That's the crux, the summary, as articulately as I can get it off the cuff.
Well, I'll motion then
Are you
first.
done with the conversation? Because once you make a motion, it's on the floor.
I was just saying.
It's on the floor. And not to discourage you, but it sounded like some other people still have some questions and some conversation.
Any more deliberation or questions? I do have a question. If the LP is approved, where on the property is it located? Yeah, you'd probably be the best person to answer that. Oh, I didn't see that. Somewhere in here. What page is that on?
It looks like here.
Right there. Okay, so it's on the north side of the property. Yeah. And the propane is up here, up on the north side of the property. Okay.
Mr. Chair, can I ask a clarification about the fire assessment fee?
Yes, ma'am.
Yeah, I found it. So, obviously it's not written into our code, but residential is 175. What would a comparable commercial fire assessment fee be for a comparable brick and mortar in that area?
I believe that the current assessment is 11 cents per square foot on commercial. Again, I'd have to verify that, but I'm pretty sure that's the rate.
Can I ask a question for the staff? With the special exemption in there, with the LP gas per se, if that got approved, will it be considered zoned now for taxes as far as the fire assessment, et cetera? Or will it still be?
You know, this is a really good question as well, and this is one of those questions that we need to send to Government Services Group. There's an offshoot of a law firm out of Tallahassee. Their neighbors, Giblin is the name of the law firm, and they have an offshoot group that provides services to municipalities. They do a lot of finance work for the cities all over the state of Florida, and their offshoot group, GSG, does a study on our tax rolls of what it would take to fund our fire service under the fire service assessment. And we pay them about every 4 or 5 years about $20,000 to do that study. And so one of the questions staff can ask of GSG is, okay, there would be a demand on fire services if, let's say there was some calamity with LP gas, or there's some sort of calamity with the produce stand. The produce stand, in my mind, is very much different than the LP gas. But what would happen from a service standpoint, as far as a freestanding produce concern, what would be the demand, or what is appropriate? And they would be best suited to say, okay, a special exception open air market would be assessed on this basis. It's a little different than commercial square footage. It's different than residential. Would there still be a need, or would it be appropriate to have a fire assessment? These are, I'm willing to bet that this has never been studied, and it may be something that would be replicated around the city. There's more than just one instance where this would be appropriate, but we would need to run that by Government Services Group to get that answer, because you want to be very careful about the assessment process, and otherwise you could invalidate the whole thing.
Yeah, I would definitely feel more comfortable having more of that knowledge of how that plays a role by adding an LP tank on a property that's open air. How that would work, especially with the fire assessment.
Mr. Chair, when you hear a lawyer say that the question has never been studied before and you'd have to hire somebody, you should see some real big dollar signs float.
Yeah,
because that's
exactly.
probably not an answer that this organization is going to give within the boundaries of what we pay them. They're probably going to recognize this has statewide implications. They want to get it right.
And I think what we can do is, the next time they're studying it, we can say, okay, answer this question. Right. And if they say, oh, this is unique and it's going to cost X amount of dollars, we can say, forget it. Or we can say, okay, it's simple. You've done this before. Tell us what the assessment level is on such an entity. So, but we shouldn't do that on this instance by itself. The next time they're doing a study, staff can tell you that will be one of the questions we ask.
Mr. Chair, I'd say it's a great conversation and it's a great question that sort of illustrates the difference between when you're trying to figure out how to make an open air market work in the downtown area and you don't have a ready-made series of ordinances and rules that you can, if you were building a brick and mortar business, you can just go to. So whenever we're dealing with the produce stand in this area, it's always kind of, we're blazing a trail as we go. We're creating it not just for the produce place, we're creating it for the concept that we want. Right now we only have the produce place taking advantage of it as an ordinance, but it's why I don't want anybody watching to get the feeling that we don't understand the rules. We do understand the rules for brick and mortar businesses. We're always having to figure out the rules for the open air market because it's a special exception. Each one is unique, and so you have to look at each individual case and what they're trying to do, which is why the special exception was written so minutely. I agree that the 4-foot hedge, it's a little too minutely, but for produce, because once you start doing other things, then you have all these other sort of peripheral questions that come into play.
Mr. Chair,
Yes, sir.
according to the city records, they do not pay the fire assessment.
Okay. Thank you. All right.
Okay. I'd like to make a motion, Mr. Chair,
By all means.
that we recommend approval of both the propane and the seafood under the condition and conditioning upon him coming into compliance with the previous special exception, and that we change item 8 of the previous special exception to say fence on 2 sides instead of 3, and eliminate the language concerning the vegetation and the vines on either side of the fence. And that the 2 sides would be the north side and the west side.
All right, we got a motion on the floor. Is there a second?
Can I ask a question
Uh,
before we have a second, or?
Yeah.
Your clarification?
Yeah. At the point where we're putting it on 2 sides and there's already a privacy fence on 1 side, what's the purpose of the fence?
Just some visual separation between the residential, which you have residential on the north and west, and then commercial on south and east.
Could I ask a follow-up clarification?
And it's a 4-foot fence, so it's not a privacy fence, which is 6 foot.
Are you envisioning it all the way at the end, or is it like up by the stand? Because this lane goes all the way down to First.
I thought it stopped short of First Avenue.
It goes all the way to First, so if
Where's the fence now?
there's there's one fence that runs north-south that separates the residential and Dollar General or Dollar?
Mr. Chair,
Thomas Keller's is
the
next
fence
door
that's there now is a privacy fence. It's between the adjacent properties. It's
Adjacent to the
to the west.
Okay.
It's not the fence that was envisioned in the resolution back in 2012, which was more of a decorative type thing. The one that's up there now is a functional privacy fence between the properties.
It's a board fence?
Yes, sir.
When you say not envisioned, is it because it's in bad repair, or?
And those are what I mean is from what I read reading the record, the intent of the 4-foot board fence with the vegetation was more of a decorative screening. It wasn't meant to provide privacy or substantial screenage from the adjacent properties. It seemed to be more decorative in nature.
And now
And
at
I
this
cut board
point,
member Baker off, so she's got another follow-up question, clarification. No, you don't? That was the same one that you had, is it?
Yeah, no, I mean,
Well,
yeah,
wouldn't a privacy fence be better than a 4-foot fence for safety reasons?
I mean, I would say that the privacy fence that is in existence now already separates the produce place from the residences, and you can hardly really see the privacy fence because most of the produce stand blocks that. There is one house at the north end, but I'm not sure that putting a 4-foot fence up on that side is going to it's not going to block the
It's
vision
vacant.
of it.
It's vacant.
Isn't everybody living
I'm
there
showing
anymore?
the satellite
I mean,
photo,
well,
it shows
there's
a house on
supposedly-
First Avenue.
That's
in the
supposedly a
property.
business,
It's
but
supposedly a
I believe
business,
that's Heinz
so.
Electric.
it's,
I believe that's Heinz Electric.
yeah, Heinz
And
Electric is down there, but
Oh, on the
I mean,
actual,
the
I'm talking about
lot,
on the other
I'm
side of
talking-
the street. That's
yeah,
what you and I are talking
yeah.
about.
On
Yes,
the
ma'am.
lot there's nothing down there on the end of the lot.
Yeah.
Because that's where you host usually the barbecues and stuff.
So do you want to amend your motion, Mr. Mayor?
I'm going to amend it to say, to just completely change it and say, I recommend we table it until we can figure out where the fence ought to be. I hate to send it forward to the commission with this much confusion about.
Table just the compliance on the fence, or table
Well,
the
we have
whole
to
issue?
table the whole thing, yeah.
Okay.
Are you in a hurry to get this? I mean, you already got your shrimp out there and. Yeah, so I mean.
Well, he's apologized for the shrimp.
Yeah.
He's
That genie's
apologized
already
for
out
the
of the
LP.
bottle, we're not gonna get it back in.
Timeline was get here before it went in front of the commission.
Well, I mean, would it break your heart if we took another
Mr.
month?
Walker, Mr. Walker, pull that microphone under you and make sure the little green light's on there. All the folks at
want me
home.
to talk?
There we go.
I'm really trying to figure out where the privacy fence needs to go, in between me and Don, or in between me and the electric company.
And
You
that's
know-
why I want to give us some more time, Mr. Chair, is to let him and Brian go out and walk that thing and say, this is where the fence needs to be. Come back to us next
I
meeting.
don't feel justified with that.
No.
I feel justified that the mayor and Brian and Mike went out would be fine.
I mean, I'll volunteer to go out. I guess my question would be, I understand the signs, I understand the banners and those kinds of things, but I don't really understand the fence
I don't either.
at all. So,
I don't feel comfortable with moving it.
yeah, I mean, if you are, I would say either table it, if the board really feels comfortable with the fence, table it till you feel comfortable with the fence, or just remove the fence requirement so you got to come into compliance with the signs.
Whenever I started cleaning that property up, Don Kelly come over to me and jumped all over me.
Mm-hmm.
You do not open my property up so people can go through it.
I just want to make sure that that legal answered the question of, because those areas of compliance were written by a previous P&Z board and approved by a previous commission. So we are still on good ground. We can recommend changing that and saying we are going to move. We're going to send it forward to the commission and recommend that he doesn't have to come into compliance with what they said before.
Yes,
I am fine. I'm fine with the sign, fellas, everybody. I am, and I'm fine with everything y'all tell me to do.
We love it when you say that to us, Walter.
I have a quick question.
Go ahead.
As far as tabling is concerned, is there a way to table a portion of it and approve another portion? I mean, if he has shrimp and fish already going, can we approve something for the shrimp and fish so Mr. Walker can continue to make something out of his catch and move to table the LP until we figure out the privacy fence and all that? Can
Yes,
we approve
we
one
could do that.
thing only and then table the rest?
Yes.
Well,
Sorry.
the way I look at it is, we're ready to move on this. It doesn't appear that a fence is an issue anymore because there's one that exists. And I know there's a fence that goes all the way down the property line. So there is fencing there. And there is a privacy fence directly behind the produce stand. I feel that really puts that part of it in compliance. If we're looking to amend the previous special exemption on the fencing, I believe that he's in compliance now.
Mr. Chair, he is not in compliance with the actual wording of what's written in the exception.
Well, I mean, that is true, but what I'm saying is if we're amending it,
Bill amends it whenever he makes his motion.
Mr. I think that
Accept the
you
fence
guys
that's
can
there.
do what you've talked about. The issue with compliance is a compliance issue. So, the question is always, you guys can put any amendments you want on there. It's, will the applicant comply? I think the central question here is the same one we started with.
correct.
Do we feel like it's okay to sell LP gas there? I haven't heard anyone talk about the shrimp, so it sounds like that's okay. So you can go with Naeem's suggestion of approving one, so that he can walk out of here with something and say, hey, if you want to come back for the LP, you got to come into compliance with these other things and bring that question back, and then we'll consider that question. Or you can say we'll approve both of them tonight about compliance, and then it's just a question of whether the previous conditions that the P&Z and the commission put on it are still applicable today. And I would say when we were thinking about this 6 years ago, that was an overgrown lot. That was an area of blight, and we were all trying to picture in our minds what it was going to look like. We can see what it looks like today, so we have a much better advantage over the folks 6 years ago who were trying to make this decision. So, but the central question that we got to answer today is this board still willing to approve LP gas? And if the answer to that is no, then all this talk about where the fence should be or how high it should be isn't really a very relevant conversation.
Well,
Can I place a motion?
yeah, the mayor's motion died, so.
By the way, y'all, I sell boiled peanuts, and I use propane to warm my boiled peanuts.
We're
So the
ready.
propane, using propane and selling propane are two different things. So,
Mr. Chair, I absolutely concur with that. It's not the same thing. There's no reason he would not be able to use propane to boil peanuts.
I'm going to motion, as staff recommends the approval of the request to sell shrimp and seafood. However, I would like to table the LP gas because of the compliance. Once once compliance is met, to bring it back to the Planning and Zoning Committee to further analyze the LP gas.
Can I ask a question? Are you going to amend the one on the fence? Accept the
Oh,
fence?
yeah, and an amend the wording on security site requirements for a 4-foot fence on 3 sides of the pavilion.
Amend it or remove it.
Remove it. So do you need me to reword that motion again, or
And
is this?
accept the fence that's there.
So the motion is to
Seafood.
approve the seafood and
And shrimp.
fish, table
LP gas.
LP gas until compliance, and
Bring it back.
and at which time, and the compliance is going to have the fencing issue removed, then he
Why don't we
can
just
bring
say
it back.
remove item 8?
Remove
The
item
whole
8,
paragraph about the fencing.
and then the applicant can come back for further analysis on the question of LP. Is that the motion on the table?
Yes.
All right.
All right, we have a motion. You have a second?
Second.
Mr.
We have a
Mr.
motion and a second?
Mr.
Yes, sir.
Chair, I
Oh,
would suggest that you table it to a date certain in the future. So that our first meeting in August would be August 6th. If the maker of the motion would accept that as an amendment.
Are we talking about just the LP
For the, yes.
Okay.
As to compliance on the.
for
on
August
the-
6th?
Okay, so he can move forward with the shrimp and fish, of course, going to the commission.
Does that amendment for the date work for your motion? Okay. All right, we had a motion, we have a second. All those in favor?
Discussion.
Oh, you want to discuss? Okay.
My only concern with the tabling for compliance based on this is that if we're looking at the other aspects of the request for the special exception for the whole LP gas issue, I think that, I know it's an expensive question, but I do think that there needs to be some sort of provision for a fire assessment. It's different than just grilling something. All other commercial businesses are required, residences are required to pay, and I hate the fire assessment fee, but I don't know that it's fair to not examine that question to keep it fair with other people who are selling it in a commercial business, who are paying their assessment. And I mean, he would still have to follow the state requirements, so that, you know, there's safety provisions, there's post provisions. This is a Newberry thing, but counting it as vacant while you're selling propane, you know, if the propane blows, it affects other lots in that area.
Okay.
Mr. Chair, you know, as the attorney said, and I've been through this for quite a few years, that the fire assessment is a very complicated formula that we pay a company, GSG, to figure that out for us. It has a lot of moving parts, and it's different for every city. So for us to ask the commission to do anything with a fire assessment outside of that study, because it'll affect other businesses that are the same, and I think it's something that we just can't handle. We can refer it to GSG the next time they do a study, and I think that's a great idea to do that. But to send it back to the commission saying something has to be done with a fire assessment, I think is beyond the scope of what we do in planning and zoning.
Does it have to go before, Mr. Chair, does it have to go to an attorney in Tallahassee for us to determine if they pay a fire assessment tax or not?
What I will do, yes, it does. And the
We
study.
can't just assess it.
No, and that's where you would get into a danger area, and if you do it wrong, and that's why we pay them a lot of money, is if you do it wrong, it implicates a major funding source for our fire department. But what I will do for Member Baker is I will call GSG generally, say, do not charge us for this, but I'm asking that you put this on. The next time you're doing a fee, we want to study this. It may be one instance, it may be many instances, I don't know. But what are the uses of property that are like this that would be potentially subject to an assessment fee? And how would you do that methodology from a general standpoint? Can this be done? If they shut it down, just you can't assess it, then we know that. And if they say, oh yeah, this is where we've done it across the state, then we'll have that knowledge. But staff will collect that information, put it on the radar screen so that it doesn't just get lost in the wayside of this thing and it goes away forever. So staff will commit to doing that. I'll get a letter out tomorrow to GSG that says that.
Thank you.
All right, before we go any further on the LP, the motion on the floor was to table the LP and vote on the shrimp and seafood? Huh?
The table was part of the motion, so you'd be voting on the whole thing all at one time.
Well, I understand that,
Yeah.
but there's still the, the discussion portion of it. Okay.
We eliminated 8, but there's still the sign. He has to have a sign.
Is there any more discussion?
Is that the only thing he has to have in place, is a sign to be compliant?
And the landscaping plans?
Is the
that correct?
signage and the landscaping?
Mr. Chair, we could, if the mayor and I go out and meet with Mr. Lee, we could look at the landscaping he has and
See if
work with him
that's-
on that and see if
Okay.
it's adequate based on the previous special exception with what he already has. And then, if the fencing issue were to go away, then that obviously is no longer an issue. And then, as far as the sign, there's no requirement to have them. It's just the ones that you have need to be compliant. And so, the temporary and yard signs would need to go away, and some kind of if you wanted to have a sign, it would need to be a permanent sign.
Mr. Chair, just to clarify Member Baker's point, what you're talking about right now is tabling it till August.
Correct.
I doubt that we're going to have an answer about the fire assessment by August. So if the other board members have the same concern, the table would have to be with enough time to find out that answer. I just want to make sure everybody's clear. Right now, the motion on the floor tables it to August, and just to August. And the chances of having, unless we call them up tomorrow and they're like, oh yeah, there's produce stands all over the state that sell LP, that's no problem. We know exactly how to do it. We probably won't be able to answer that question for you guys when he's back in August.
It
And-
probably wouldn't be for a long time after that, right?
Right. And Mr. Chair, I understand that this is like, the fire assessment is a complicated issue and has been for many years. I know we pay somebody but I thought it would be negligent not to mention my concern on the record as part of the motion. So that is on the record, and that's what the discussion part before we vote is for.
Thank you. Any other discussion before we vote? Or actually, any other comments from the public on the motion on the floor? All right. We've had a motion, we've had a second. All those in favor, say aye.
Aye.
Aye. It's unanimous. Motion passes.
We got another meeting with the Historic Architectural Review Board.
All right. We no longer have topics, well, actually, we do, topics from members for discussion. Bill, you got anything?
No?
Nine? No. I've got nothing. Wanda?
Just everybody have a safe 4th of July.
I have nothing.
Mr. Mayor?
I just wanted to offer my condolences to Mayor Conrad, who recently suffered loss of a river house where he made lots of fond memories. We do feel bad for you. When we found that out, all our hearts went out to you. We know it's you're lucky that nobody got hurt, but there's lots of memories and sentiments in that. And I hope you have plans to rebuild it, and I see lots of pictures with you guys on the river in the years to come. So
Thank you.
that's all I have.
Mr.
Sure
Attorney?
glad you got that 22 out of there. It's good to see.
And the TV remote.
All right, all right.
Away with that.
All right. Planning and zoning meetings adjourned.
We got Historic Architectural Review Board meeting now.
Is there a bathroom break?
This shouldn't take 5 minutes. But there's a bunch of administrators who got
All right, we'll take a few minutes for bathroom. right, good evening. Welcome to City of Newberry Historic Architectural Review Board meeting. Today's Monday, July 2nd. We'll start by reading the agenda. So we have 1 is call to order, 2 is approval of agenda, 3 is approval of minutes from last month, June 4th. We have 4 is old business, A, update on historic preservation special category grant for LRSH, 5, new business, 6, topics for members for discussion, again, election of officers being under that, and 7, we adjourn. All right,
Motion to approve.
Second.
got a motion and a second. All those in favor?
Aye.
Passes unanimously. All right, did everybody have a moment to look through the agenda, or through the minutes of last month?
Yes, make a motion, we approve.
Got a
Second.
motion and a second. All those in favor?
Aye.
All right, motion carries. Puts us on old business. Update on historic preservation special category grant. Miss Wendy.
Mr. Chair, Wendy Kinzer, Principal Planner of the City of Newberry. Just letting you know that the application is under review by the state. We are still collecting some letters of support, and we'll be sending all of those in together, additional letters, and we're waiting to hear something. So they did ask for some additional information, and we're just hoping that we'll be in the running for that money that we need to improve the Little Red Schoolhouse, the LRSH.
All right, we have no new business. That takes us to topics from members for discussion. We've had our election for the Planning and Zoning Board. Do we want to use the same results for this board, or do we want to elect different officers?
Motion to elect Walt Boyer as chair and Mayor Bill Conrad as a co-chair,
Vice Chair.
Vice Chair.
Second.
vice chair.
We got a motion
Second.
and a second. All those in favor?
Aye.
Aye. All right, motion carries. All right, any other topics, anything else you want to talk about? Bill, Naeem, Wanda? Jessica?
Wendy's got something.
Wendy?
I have one really quick thing of training. Now that we have a full board, so we're going to go ahead and let them know they have their new person on board the state to do the training. We have all of ours. And so we want to go ahead and look at that. So are you still thinking that you want to do it during a regular meeting, as in like, hopefully
Ms. Wendy,
something that
could you,
isn't
for the
going to
new
be...
board member, could you talk about what training we're talking about, the timeline that we're talking about, and those kinds of things, so he's up to speed?
I thought he
Let's
was
bring him up to
clairvoyant.
speed.
Thank you.
Historic preservation, having to do with the certified local government and with historic preservation in general for the responsibilities you have as a board, a historic architectural review board. So we have, the state has a division that addresses certified local governments, which is what the city of Newberry is also. To qualify for that is you have to meet certain requirements of having a certain kind of ordinance, our historic preservation ordinance, and having an historic architectural review board, and following a few different kinds of procedures. That's, you qualify, the city of Newberry qualifies as a certified local government, which makes you able to get certain kinds of grants and certain kinds of funding and certain kinds of training. It helps you participate in some of that, and you get certain kinds of assistance from the state.
It's a
for
short 9-hour
technical-
class. Walker will provide some pizza for you.
They do have training that certified local government, like you can go for a day or two, where they have some other kinds of workshops elsewhere. We're looking at just doing a workshop here for a couple of hours that people would be able to kind of get some information and open it up to the public. So if anybody was interested, especially those who have homes in the historic district or businesses, so that they can hear some of that as well. Just, we ought to do something like that regularly anyway. So that's the idea of what we're talking about now. And we have a, I don't know if you were provided a, do we do the handbook? Yes, okay.
Oh, this big old binder?
Yes.
Yeah.
And there'll be a test next week.
Awesome.
I'll be calling you, setting that up. It is a written exam.
We can give them till,
That should
We
coincide
can
with
get
my
that
financial
P&Z in
accounting
Harvard.
exam coming
Oh,
up.
yeah,
Thank you.
right.
we'll give him until August 6th for the exam.
Okay.
Thank you.
Okay, well, anyway, so is there any, I mean, you still want to go ahead and look at doing it on a regular meeting night as doing 6 o'clock? You have your meeting and hoping that it gets done early enough to do a 7 to 9, or what do you think? Any ideas? Any other thoughts on that?
I would probably offer, if you can schedule us a light P&Z meeting, that way we can follow that.
Sure, we
Something
can sure guarantee
non-contentious.
that, can't we?
Yeah, and let's follow a non-contentious P&Z
We'll certainly
meeting.
try.
We can
And
certainly, yes.
um,
It's a lady now, a new person who's come on board, and they're just getting everything scheduled now. So some of them, they haven't scheduled any of them yet. So a month, at least a month. So she hasn't provided. No, we don't, not for sure. But actually, we are the first one that kept asking for training, kept bothering them until they finally have the new person hired. So they are looking at trying to accommodate us as best they can. So as soon as we know some possible dates that they have or what their schedule is, what they're looking at, I mean, she already knows what, we had asked for before.
well,
So,
I'd also
but I know
offer,
what you're saying.
depending on what dates they have available, I mean, if they can't accommodate us to come to a meeting, I don't have a problem accommodating them on their availability either. I mean, as long as everybody else agrees. But I think it's important that we partake in this.
Yes. Well, I'll definitely, whatever they come up with, they know our schedule. So, and then if they have some other ideas for dates or times, we'll let you know, and then you all can decide what would work best for everyone, so that everyone can attend. And it is really helpful. Yeah.
I mean, if we don't have it, that scheduling thing, you send out people and ask them what their
Yes.
availability is.
Right. Yes.
Maybe
Yeah.
send
We can do
it out.
that.
That would be a violation of sunshine law, but
No. When you mark
send
the
that
dates
out,
that you're available in
we'll
time,
be able to
yeah,
do
that survey kind of thing. Yeah, we can do that. That's a good idea.
Can I ask a question in terms of the public? Could we flip the meetings and I don't know, do the training?
You have to come introduce yourself in the microphone, let us know who you are.
Don't
We're
holler
still
from
in
the
a
back of the room.
public meeting.
Janine Marinac. Could we flip the meetings and either start the training at 5 or 5:30, do the training,
mean
and
start
then
the
do
meeting?
planning and zoning?
Do the Historical Architectural Review Board meeting first?
Piece first, and that way anybody who needs to come doesn't have to wait here till 9 o'clock. Is that
And
what you're saying?
do the historical architectural meeting that has the training in it, even started early and then, I don't, just,
I would recommend you've already got Mondays scheduled on your calendar, so making it a longer Monday is probably easier than trying to get everybody on a different night of the week.
Yeah.
So, and I don't think that there's necessarily a huge time commitment. We don't need to get this thing done. I know that staff would like to check this box and get it out of the way, but if we can,
But we're still looking at a couple of hours though,
Well, we're
right?
not checking the box to get it out of the way. This is very
this
important.
is a very important. We're all going to go away very educated here. I
So
did
how
not
long
in
is
any
this
way
meeting?
mean to demean the
Exactly.
training.
Is
What's
it
that?
9 hours?
No, I was a joke. It's 2. When staff says 2, that probably means more like 2.5, maybe 3.
I feel like we would have to have a very specific time to start the P&Z meeting because of the nature of that meeting.
I think it's a good idea. You change the P&Z meeting, let the P&Z meeting happen at 5:30. That way, anybody who's got business doesn't have to wait for that. Because when they say 2 hours, that means it's presentation. You guys are going to ask questions. You're going to have comments. We're going to make jokes. All that stretches the night out.
So are we talking about moving the P and Z meeting earlier, starting the P and Z meeting earlier, or are we talking about swapping the two and doing the HARB first and then P and Z afterwards?
You can do what you would like, except you have to advertise. So the Planning and Zoning Board, public hearings, that kind of thing, it has to be after work hours for people to be able to attend. And we can do what you would like, flip things, do your one meeting earlier, one later. The main thing is that if there's public hearings, you know, for
Unless
the
we're the
Planning and
county
Zoning Board.
commissioners, we could do meetings at 9 in the morning.
The main thing
Mr. Chair,
is you
let's-
can
I don't pretend it
advertise
went through
whatever
this
you
year.
would like to do, and as long as we put public notice out there and what you would like to do, and considering who you want to attend.
Well, I guess the first things we need to do is find out their availabilities.
Okay, well,
And
we'll do
then-
that.
And then work from that point forward.
Okay, all right.
Do
We'll
we
do
need a
that.
motion for this?
No.
Yeah, but that's, okay, that's good, and I'll let them know. I mean, I'm already in communication, they know what the schedule is, but I will offer that if there are other times or dates, if that can't work out, what are their what is their availability?
Okay. Any other topics from members?
Thought we had a good meeting tonight, good deliberation, a lot of good thoughts. Appreciate the new member, and congratulations to Walt. being our new chairman.
Congratulations to you, Mr. Mayor.
I'm honored.
I myself would like to again welcome and congratulate Naeem for volunteering and blessing us with his presence.
Well, it's a pleasure and honor to be here. Thank you very much for having me. And thank you. All right. Happy 4th.
All right. Everybody have a very safe and happy 4th. And this meeting is adjourned.
Why did I always think that the fireworks for Newberry were done on their property?
On mine?
Yeah. It was a bowl or a hole.